Greetings and welcome to IBI, India Business Insights. Our video today is on the Factories Act 1948. The Factories Act of 1948 establishes the safety requirements for employees working in factories. Factories that produce items such as weaving, hosiery, and another knitwear, knitting, apparel and footwear manufacturing, textile dyeing and finishing, etc. The primary goal of this act is to regulate the working conditions in factories, regulate health, safety, welfare, and annual leave, and enact special provisions in respect of young persons, women, and children who work in the factories. The Indian Parliament passed the Factories Act in 1948. The act is a significant piece of law designed to safeguard the interests of workers, stop their exploitation, and take care of their safety, hygiene, and welfare at their places of work. Since its commencement, the Factories Act, officially known as the Factories Amendment Act 1951, has undergone 4 revisions to suit better the requirements of India's industrial environment and commercial activities. In India, the Factories Act is categorized as labor law. Objectives of the 1948 Factories Act are to ensure the workers' health and safety, to ensure that factories follow the world's best case practices, to ensure that all working-class individuals have a fair and decent means of livelihood, to ease any tensions in the workplace or society, provisions of Factories Act 1948. The Act establishes minimum salaries and working hours. By establishing a set pay rate, the Factories Act of 1948 requires that workers receive minimum wages. Employers are required to pay their staff at least the legal minimum wage. If an employee is paid less than the legal minimum wage, the employer is required to make up the difference. Employers are reminded by this act that breaking any of its rules could result in severe legal repercussions. The working hours for all employees are governed by the Factories Act of 1948. As per the Act, a working week cannot be longer than 48 hours. In order to prevent overwork and excessive exhaustion of workers, this aims to control the numbers of hours and working time in workplaces. Further, the Act set a 48-hour work week maximum and maximum working hours of 9 hours per day. According to the Act, companies must give their employees a weekly holiday. Additionally, it mandates that the employer offers suitable sanitary facilities and a clean source of potable water in the factory or workplace. If the employer fails to give the employees these amenities, strict action will be taken against them. Additionally, employers are obligated to set up first aid stations in their workplaces, keep first aid records, and make sure that the necessary preparations are made for transferring wounded employees to local hospitals or on-site medical centers. Period of application. Following the general elections held in 1951 for the Legislative Assembly of the States and Union Territories, the Factories Act was put into place in India with effect as of June 15, 1951. Additional amendments to the Factories Act of 1948 were made in 1951, 1960, 1961, and 1972. Along with this modification, the rules from 1951, 1960, and 1961 have also been altered. The chief secretaries of these states applied the Factories Act to the newly created states in 1965, which only applies to specific factories with 10 or more employees. Below are some important judgments that interpreted a few important definitions in the Act. According to the 2007 case of Lal Bafta Hotel or Bakery Mazdoor Union versus Ritz Private Limited, the establishment of a hotel would not be considered a factory under Section 2, Clause M of the Act. All of the employees of the construction company fall under the definition of workmen as it is used in Section 2, Clause I of the Act, since they are participating in the project's manufacturing process for payment. This comes from the case Lal Muhammad versus Indian Railway Construction Co. Limited. A commercial institution that receives bulk products unpacks them and packs them in accordance with customer requests before sending them to customers. Such an action constitutes a manufacturing process as defined by Section 2, Clause K. Barry Co-Lieutenant Presiding Officer 2nd Additional Labour Court, Madras, 1998. Health and safety provisions for women provided under the Factories Act 1948. Section 19, Latrines and Urinals. The provisions for health and safety are provided in Chapters 3 and 4 of the Act, respectively. According to the Section 19 of the Factories Act, every plant must offer enough lavatory and urinal facilities for men and women that are always accessible to all of the workers. The employer is required to keep the restrooms and urinals adequately clean and hygienic at all times. There ought to be a laundry facility close by as well. All of this is crucial for maintaining the workers' health. Section 22, Work on or near machinery in motion. The Act makes it very explicit in Section 22 that no woman or young person shall lubricate or adjust any machinery or any portion of any machinery while it is still in action. This section was created to protect women and children from any potential injuries. Section 34, Excessive weights. According to Section 34, the state government in question has the authority to establish regulations governing the maximum weight that men, women, and younger workers in factories may lift. The Act emphasizes that no one should ever be required to move or lift any weight that could endanger their health or cause them harm. Section 27, Prohibition of employment of women and children near cotton openers. According to Section 27 of the Act, no woman in employment is allowed to work in any area of a factory where cotton is pressed or where a cotton opener is utilized. Given the great likelihood that the cotton bales would catch fire, this is done to protect the women's health. The following sections of the Factories Act state the obligations of the occupier, the factory manager. Section 41G, Participation of employees in safety management. The occupier shall establish a safety committee composed of an equal number of representatives from workers and management in each factory where a hazardous process is carried out or where hazardous substances are used or handled in order to foster cooperation between workers and management in maintaining proper safety and health at work and to review periodically the measures taken in that regard. Section 41H, Right to modify employees of impending threats. If an occupier or manager in charge of the factory believes that there is an immediate danger to the worker engaged in a hazardous process, he or she is required to take immediate corrective action and send a report of the action taken to the nearest inspector as soon as possible. Section 42 to 49, Welfare. The occupier has a responsibility to provide all employees with welfare amenities such as lunchrooms, canteens, child care centers, laundry facilities, first aid kits, etc., and to appoint a welfare officer. Section 61, Notice of Period of Works for Adult. The factory manager is required to properly display and maintain in each factory a notice of adult work periods, clearly displaying for each day the periods during which adult workers may be required to work, and further classifying them into groups based on the nature of their work and indicating the number of workers in each group. Section 62, Register of Adult Workers. The manager of every factory shall maintain a register of adult workers to be available to the inspector at all times during working hours or when any work is being carried on in the factory. Section 89, Notice of Certain Diseases. Where any worker in a factory contracts any disease specified in, the manager of the factory shall send notice thereof to such authorities and in such form and within such time as may be prescribed. Section 91A, Safety and Occupational Health Survey. The factory's owner or manager must conduct safety and occupational health surveys, and they must provide all necessary facilities of these surveys, including areas for inspecting and testing equipment, gathering samples, and other survey-related data collection. Penalties under Factory Act 1948. Section 92, General Penalty for Offences. In case the occupier or manager of any factory violates any provision of the Act or any rules made thereunder, shall each be guilty of an offence and subject to punishment, which may include imprisonment for a maximum term of 2 years or a fine of maximum 1 lakh rupees or both. The fine shall not be less than 25,000 rupees in case of an accident causing death and 5,000 rupees in case of an accident causing serious bodily injury. Section 94, Enhanced Penalty after a previous conviction. If any person who has been convicted of any offence punishable under Section 92 is again found guilty of an offence involving a contravention of the same provision, he shall be punishable on a subsequent conviction with imprisonment for a term which may extend to 3 years, shall not be less than 10,000 rupees, but which may extend to 2 lakh rupees or with both. Provided further that where a contravention of any of the provisions of Chapter 4 or any rule made thereunder or under Section 87 has resulted in an accident causing death or serious bodily injury, there shall not be less than 35,000 rupees in case of an accident causing death and 10,000 rupees in case of an accident causing serious bodily injury. Changes brought about by the Factories Act 1948. The term factory was expanded to include all industrial establishments with 10 or more employees where power was employed and with 20 or more employees in all other situations. According to the Act of 1934, the state governments had the authority to apply the Act to establishments with more than 10 employees. According to the Act of 1948, the state government may apply the requirements of this act to any establishment, regardless of the number of employees engaged there, the number of workers employed there, or whether manufacturing work is performed manually or using power. The basic provisions of the old Act relating to health, safety, and welfare are extended to all workplaces, irrespective of the number of workers employed, except premises where processes are carried on by the occupier with the sole aid of his family. The minimum age for allowing children to enter the workforce has increased to 14 years, and the minimum daily hours of work for kids are now only 4.5 hours. There are provisions for the licensing and registration of factories, as well as the prior inspection of the designs and specifications of factory buildings by the Factories Inspectorate. It is not permitted to employ women or minors between the hours of 7 p.m. and 6 a.m. The workers are entitled to double their regular rate of pay for overtime labor. In conclusion, the present Factories Act has provided ample benefits to factory workers. It has considerably improved their working and employment conditions. The government is actively considering the introduction of some vital amendments to the Act to keep it in tune with time and make it more effective. While dealing with the duties of the occupier and factory manager under Factories Act of 1948, altogether we can conclude that the occupier and factory manager has a vital role to play in assuring the health, safety, and welfare of the workers, as they are the backbone of the industrial sector. It is, however, necessary that the workers and their representatives make themselves aware of the various provisions of the Act and safeguard their interests on their own, and force the defaulting employer to be conscious of their legal obligations.
If you watched this video so far, I'm sure you found it interesting. I would urge you to like this video and subscribe to our channel.